You are listening to Lone Star Community Radio on 104.5 KCZWLP Conroe and 106.1 KZCCLP Conroe and worldwide on irlonestar.com.
Hi, welcome to the Legal Connection Show. I'm Tony Collins. I'm an attorney here in the Conroe area, licensed in the state of Texas. We have a show that we do every Tuesday at noon, between noon and 1. You can get us on FM 104.5 or FM 106.1 in the Conroe area. You can also catch us on Facebook at the Legal Connection Show, or you can look up our different shows if you miss a part of the broadcast today on irlonestar.com. Under the Legal Connection Show, and you'll also get us on YouTube if you just Google it. You can catch an extra. You can catch the shows just by Googling a topic and Legal Connection Show on YouTube. Okay, so today's show we're going to cover probate, and you know, when I was preparing for the show today, I thought, what is the purpose of having a will anyway? Since if you are, if you die, you come into the world with nothing and you leave with nothing. So what purpose does a will serve, really? I mean, it won't matter once you're gone. And so I thought, what would Aristotle think about a will? I thought certainly Aristotle wouldn't have a will because he's the most logical man that ever lived. And when I looked it up, I learned that Aristotle actually did have a will, which stunned me. There was a number of people in recent past that didn't have a will when they died. And the first one that came to mind was Prince. He had this, he was so tedious in life and so protective of all the songs that he wrote. And he had this whole library of songs that he would never give the licensing out to. And, just a very, very wealthy man from Minnesota, quirky but highly talented. And, the first song that comes to mind is 1999. And, I guess he had Purple Rain. But at any rate, he didn't have a will, and he didn't have a wife, and he didn't have kids. So it was odd that he, in life, had so many things that he accumulated that he didn't take care of that. He didn't take the time after all the writing that he did to actually draft a will for what would happen to the things after he died. There are a number of people in history that did not have a will, and I, for one, don't really think a will is necessary, but I thought, let's see what Aristotle thought. And then I thought, what about Dean Treese? I guess it's T. Gerald Treese of South Texas, my mentor. I was on his moot court team. He taught constitutional law, just a brilliant man that guided so many people so many lawyers at South Texas that just looked up to him. And really, he trained us to write appellate briefs and how to think logically. And then I learned he had a will, but it was literally a one-page holographic handwritten will. I looked it up. It was probated in Harris County, and I literally printed it, and I have it at my house in my study because it was just so simple, handwritten, everything to his wife. I think that if she didn't survive him, that it would go to his children. I think he had 2 daughters, but his wife did survive him. And I was just intrigued by, here is a man that basically put South Texas College of Law on the map, being one of the top appellate schools in the nation, the top 4 or 5, right there, I think, above Harvard Law and the Ivy League schools. And he only had a handwritten will. So anyway, here's what you need to know about Aristotle, a man that actually did have a will, and Dean Treese, who also did have a will. And so that prompts me to create a will. If they believed it was important, then maybe there is some importance to it. So we're going to go over that today. All right, Aristotle. He is Greek, like my husband, and there are other important people that were from Greece in history, including Cleopatra, who lived just 30 years before Christ. And, she married, or not, she had Mark Antony's children. She was right there in the throes of all the during the Roman Empire, being politically persuaded by trying to make Greece relevant during all of the warring factions during the Roman Empire and what have you. But anyway, she was also an important Greek person. I lost my what I was going to read about Aristotle. Okay, Aristotle. I never took philosophy, so I was very interested in teaching our listeners a little bit about him. He was born in 384 BC. I thought he was alive much longer, way before that, in other words. And he was born in northern Greece. He died at the age, between the ages of 61 and 62, which is my age right now, in 322 BC. He went to school. He was taught by Plato, another very famous philosopher. He was in the era of ancient Greek philosophy, and his notable students were Alexander the Great and a couple other people that I cannot pronounce their names. It is Greek. His main interests were basically everything. He had politics and poetry, then ethics and metaphysics and physics and biology, and so he was like a well-known scholar of his day. All right, so here's what the Wikipedia says, and of course I fall back on all things wiki because I think it teaches you so much in this age of digital knowledge. Little is known about his life. Aristotle was born in the city of Stagira in northern Greece. His father was Nicomachus. I don't know how to pronounce that. He died when Aristotle was a child, and Aristotle was brought up by a guardian. At the age of 17 or 18, he joined Plato's Academy in Athens, which is where my husband's mother was born, or a suburb of Athens. We actually have, or my husband's family has a little villa there that I visited a couple of times. Right, you can see the, I guess is it the Pantheon, or is that in Rome? I forget, but you can see the ruins from where my husband's villa is. Anyway, he remained there until the age of 37. Shortly after Plato died, Aristotle left Athens at the request of Philip II, who tutored Alexander the Great. He established a library, and Aristotle's views profoundly shaped medieval scholarship. The influence of physical science extended to the late antiquity and the early Middle Ages into the Renaissance. You see these bronze busts of Aristotle everywhere because he was, I guess, the father of logic. Aristotle's influence on logic continued well into the 19th century. In addition, his ethics, though always influential, gained renewed interest with the modern advent of virtue ethics. Aristotle has been called the father of logic, the father of biology, the father of political science, zoology, embryology, natural law, scientific method, rhetoric, psychology, realism, criticism, individualism, and meteorology. So apparently he influenced just about every form of scholarship that is taught today in our colleges. It says that, to go a little bit deeper into his upbringing, his parents both died when he was about 13. Let's see. I think we've gone over pretty much everything else we need to know about him that I had any interest in. It says, while in Athens, his wife Pythias died, and Aristotle became involved with something else which I can't pronounce. I guess that's a woman's name, who bore him a son, whom he named after his father, and various other things. And now I'm losing complete interest in all the stuff that is Aristotle. The main thing I wanted to talk about Aristotle today was he actually had a will, and this interested me because I thought the most logical man on earth in our history actually had a will, when I didn't think a will would be necessary. Somebody that was logical would not feel like if you were going to die that it would be important to say where your things should go, because you don't have any control over that after you die. Anyway, this is what his will said, and I'm just going to paraphrase before I go into why wills are important to you in Texas. So this says the last will and testament of Aristotle was in 322 BC, about 300 years before Christ. His will says, all will be well, but if something happens, Aristotle has made the following dispositions. Antipater was to be his executor in all respects and in general. But until Nicanor, Aristotle's adopted son, takes over, then he lists about 3 or 4 people that would be people that would take care of his children, and his, I guess his lover, her Vilius, and would go his children as lover, and this would be how his estate would be inherited. Apparently, he was very well off. It says, when my daughter is grown up, she should be given to Nicanor in marriage. So apparently his will says who his daughter is going to marry. If anything happens to my daughter before she marries or after she marries, but before she has children, then her husband is to be the curious of my child. Her husband's supposed to take care of his daughter and to see if anything else. Boy, this is really hard to follow, so I'm just going to skip right on over this. It says that his executors are going to be another Greek name that I can't pronounce, that he had provisions for slaves, so he had slaves, apparently, that when my daughter marries, she shall be given 500 drachmas and a female slave that she has at present, that she will receive in addition to the female slave that she has now, another female slave. There will be provisions for commemorative statues. Okay, so there's going to be the executors to decide that the images of Grillion has been commissioned to make set up when they are finished. Various statues of Aristotle. Maybe that's why there are so many statues of Aristotle out there. And so basically he's even everything with his daughter and providing for her. That is really surprising to me that he even cared, but he did. Okay, to go off on a slight tangent, when I was reading about wills, there was the CNN had an article on 10 uses for your body after you die. So if you're curious about how to give back while you're still alive, you can direct that your body be used for charitable purposes. And so here are the ways that you can do it. If you go to an attorney, they can draw this up. 10 ways you can put your body to use after you die. And in many cases, you can do more than just one of these. You can donate your organs. You can will your body to a university. You can donate your tissue. You can help doctors practice their skills. If you prefer to be worked on by folks and are more experienced and actual, not feature doctors, you can donate your body to a university. You can leave your body to a body farm. That's just something they're suggesting. I think that's really odd. You can become a crash test cadaver. You can give your body to a broker. And we don't mean a stockbroker. We mean a body broker. And they will take your parts and give them to scientists who will use them for research. That sounds awful. Send your body on tour like Body Worlds exhibits. You can become a skeleton. Researchers from around the world visit the extensive skeleton collection in Maxwell Museum at the University of New Mexico. And you can be on display to a museum. Okay, those are all just really odd things to do. I would be afraid to do anything more than want to give my organs, which you can do when you get your driver's license. You can register at that point to give, they give you the option to ask whether you want to donate your organs, and you can check off that there at the GPS if you want to be so charitable, which I've done because I think that that's kind of important. And I will add as a sidebar that my friends added on my driver's license as a joke when I was in high school, when I got my driver's license, that I should donate my elbows because I had multiple elbows from playing tennis or something. I had, it was kind of an odd thing, but they thought that was funny that I should donate all of my elbows because I had more than enough to give away. I don't think that they have that on my driver's license anymore, but thank you, Dr. Vicky Short and Fran Carter-Valsa Miranda, for adding that to my driver's license. Okay. Now, about wills. I had a question from one of my clients, and they asked, my husband does not have a will. I told him how important it is that everyone have a will. He says he's very stubborn. What will happen if he dies without a will? Will his assets go to the state? And the answer is, if you die without a will, in Texas, the state effectively writes a will for you. There are very specific laws that determine whom your property passes to after your death. The determination is based on the type of property, where it is, where it is located, whether it is separate or community, and who survives you. For an example, the property distribution will depend upon whether there is a surviving spouse or children. Only in the event that there are no living heirs would the estate go to the state of Texas. In your case, and so like for an example with Prince, his estate would have been determined by the laws of the state of Minnesota because that's where his residence was. And he had no spouse and he had no living children. And so, of course, everybody came out of the woodwork saying that they were, a sister, brother, cousin, whatever in his case. I don't practice law in Minnesota, so I can't tell you how that distribution went. But in Texas, you can go to the estates code. You can just Google it, and it will show you how an estate would be distributed depending on who the surviving heirs are of that person. Of course, if you're talking about your husband, then you would be, at the very minimum, you would go to where it would state intestate with a spouse. Of course, if he's still alive, you may, after listening to the show, want to have him create a will. So it all goes how you may ask him to distribute it, which is all to you. Okay, in this woman's case, her husband's estate would probably go to her, assuming he does not have any children from a prior marriage. If you're the second spouse, that would not be the case. You'd have to go to the laws of intestate distribution of a spouse who was previously married. And in that case, it usually goes, well, don't want to go into a lot of detail with that because it depends on whether it's community or separate property. In general, half would go to the spouse and the other half would go to the children, but without knowing the characterization of the property, that's too general. So you'd want to go to the estates code to look how it's split up. Having a will is the only way to precisely determine where your property will go after your death. There are reasons to have a will other than the determination of how your estate is distributed. For an example, without a will, the process of probate may be much more complicated and substantially more expensive for your heirs. In other words, having a will is a good way to save your loved ones a lot of time and money. But, if you die, if you're like Prince, it may, or if it doesn't matter to you, then you wouldn't want to go to the expense during your lifetime of having to draft a will property. I will say that a holographic will, like Professor Professor Treese created, is perfectly legal. That's why he used it. Here's the, one of the finest minds in law, fully educated, taught just thousands and thousands of students and judges and, I can't even say all the people that were taught, like Aristotle, by Professor Treese. He had a handwritten will. It was perfectly legal, and it was probated. And, of course, I have that as I said earlier, in my study. I just thought it was so fascinating. All right, so what I want to say about a holographic will is as long as you write it, it says it shows to be a will. I think writing a last will and testament on top or will on top and having a signature and a date to show that it was drafted, before you died. I don't think the only people that wouldn't want to have it probated, to have it proved up, would be somebody that could authenticate the signature. And that would be it. If it's a typed will, If you have to go through the will dance, it's a little bit more complex. You can have a self-proving will. I advise you have a self-proving will, because if the people where your witnesses die, then it's difficult to prove it up in court, but can be done. Okay, so here's some frequently asked questions about the assistance for the elderly. And so this goes toward if you're still alive and very old, and just some questions that I have from people that have parents that are older and they need some questions that are answered. All right. Someone is taking advantage of my elderly relative. This is what comes into play when you have somebody that is manipulating an older person to create a will, making them the only heir. This happened with a really good friend of mine. Her mother had a cousin that unduly influenced her elderly aunts, and they changed their will in their late 90s to make him the heir. And so what can you do about that? First, in Texas, if you have a legal duty to report abuse or neglect to the Department of Protective and Regulatory Services, that's the Adult Protective Services, by calling a toll-free number that's provided, and you can Google it, and I don't have it in front of me right now. This undue influence is not necessarily abuse or neglect, but it could be deemed abuse if they're really not caring about them, but you're really just trying to manipulate them into changing their will to make you their heir. That's unethical, and it can be a form of abuse. But just kind of bear that in mind if you're the person that feels like that you're being cut out of the will by a manipulative relative. That you believe that they're also abusing them. They've moved in with them and what have you. You can call Adult Protective Services in Texas to have them go do a welfare check. The next question I get is, should I ask for a guardianship? If you suspect your elderly relative is legally incapacitated and unable to take care of himself or herself, a guardianship may be appropriate. This doesn't go toward undue influence, but certainly if you suspect that somebody needs care, then a guardianship is appropriate. The state of Texas can handle it. They can appoint somebody for that person if you don't live in the state with them or you have a concern. For more information about guardianships, then you can go to texaslawhelp.com. It's a state digital, I want to say digital, it's a state website, and if you Google adult guardianship, then it will walk you through the steps that you need to take. The next question I get is, what if my relative needs help managing his or her money? Of course, everybody wants to jump in and help somebody that's got tons of money that needs managing it. There may be somebody that doesn't have as much, and maybe you're too busy, or you feel like you're not qualified. Your relative, and the answer is, your relative may have access to some assistance depending on where she lives. Texas has 23 local management programs that receive state funding for providing bill paying and other services. So I would, again, Google Texas Law Help. They can guide you to somebody that can help manage their money. I would go there first. That's probably the most ethical thing to do than jump in and try to become their guardian, and then also making a lot of or losing a lot of friends along the way that think that you're just doing it for selfish purposes. All right. So recently I wanted to go into trust and trusteeship just for a minute, because it's a question I get a lot when there's living trust involved, or when somebody that learns that there is a trust and that somebody is a trustee. And trusts are, and we've had shows on trust before, and you can go Google one of my past shows on why to set up trust and what have you. But I get a lot of trust about trustees and whether they are providing the services that they are supposed to, and if they are, if you're unhappy, if you learn that there's a trust, that your mother set up a trust, your father set up a trust, there's a trust in place, and then you learn that you're a beneficiary. If you're unhappy with the way the trustee is providing services, whether it would be a bank or a relative, what do you do? And so here's some questions I get about that. I am a beneficiary of a trust. I am not happy with the trustee. What can I do? And this goes toward whether this is a trust for an incapacitated child or adult, or if it's from a trust that was set up after someone has died. Texas statutes and case law give beneficiaries certain rights and remedies in the Texas Estate Code. The first place to look is in the trust document, though. So don't go directly to the law, because that's the guiding, I guess, the guiding document is going to be the trust document itself. The trust instrument will provide the beneficiaries and all the provisions of the trust. As a beneficiary, you're entitled to a copy of the trust. So you want to go to the trustee and ask for one. If they won't give it to you, you can basically sue them to give it to you. You can. I can't imagine that the trustee wouldn't provide you with one, because that in and of itself would be a breach of the fiduciary duty, not giving you a copy of the trust to review. So the next question I get is, I can't figure out what the trustee is doing with the trust funds. Do I have a right to know? And the answer is yes. Trustees are fiduciaries and owe certain duties to the beneficiaries of the trust. If you are a beneficiary of the trust, the trustee has a duty to provide you with that information and a copy of the trust. The next question is, what if the trustee will not give me the information I want? The trustee's failure to comply with a reasonable request for information may be a breach of the trustee's fiduciary duty to you as a beneficiary, which can be a basis of a suit for you that you'd want to file to get that information and basically get them ousted as a trustee. And there's a lot of other things that go along with that, the damages and that breach of just not giving you the information is going to be a breach, and you want to go talk to an attorney about that. You can contact me at thelegalconnectionshow.com, and there's a, I can guide you with who you need to contact to look at that. If it appears the trustee is mishandling the trust property, then what should I do? This is what I get quite a bit. You should have an attorney review the trust to see if it contains provisions relating to the removal of the trustee. If the terms do not provide for that, then you can ask the attorney further to file a suit to go further and look into what you need to do to get the trust properly handled, to get another trustee in place. If the trustee is doing a terrible job, and you've already looked at all this stuff, and you've had a chance to review the finances, and you learn that they're doing a terrible job managing the property, and it's also declined in value, then what can you do? The fact that the trust investments have declined in value probably is not by itself a breach of the trustee's duty. The trust instrument may include information on the investment standards and what you can go for, what your options are. All right. So I get a lot of questions about trustees that aren't doing the job, trustees that are self-dealing, that they're not investing properly. This usually goes toward when there is an incapacitated child or somebody that has that's not mentally competent. I guess if they have enough, if they're not completely incapacitated, they may be looking at trying to get the trustee replaced, whether it be a bank or another trustee. And so there's usually provisions for that in the trust. But that's what I'm getting questions from that side of it, living people that are saying that the trustee's not doing their job. Okay, so this is another set of questions I'm getting about living trust. And it's become sort of, I guess, vogue these days for in order to circumvent having to probate a will, for a living trust to be set up in lieu of a will. And so I'm getting these questions about living trust. And so for those people that have a will as well as living trust, here are some answers to your questions. Is a living trust a good idea? Living trusts have become popular alternatives to traditional wills as estate planning documents Determining if a living trust is the best solution for you depends on your circumstances. And so the question is, what is a living trust? A trust is a legal device used for the management of property. In a trust, legal title of the property and the right to manage the property is held in the living trust. The next question is, how does a basic living trust work? In a typical case, the creator of the trust, called the settlor or the trustee, names himself or herself as the initial trustee and the initial beneficiary. And what happens is it's set up it's usually set up between spouses while they're still alive, so that they can circumvent the will actually having to be probated. The problem with living trust is they have to be funded to become effective, and they usually is set up so that when one spouse dies, it will automatically populate. But because trusts aren't actually they're not something that's filed, they're not of record. If you have a will contest, like if the trust is set up with a second marriage, then you may have the children from the first marriage of the spouse that's deceased contesting whether the trust is ever became effective or if it's legitimate, and so you may have some problems with that. So that's just something I kind of lean toward probating the will if you're going to run into some an honorary child, or if you believe there's going to be a contest to the effectiveness of the trust. Okay, so the next question is, if you have a living trust, a revocable trust that's set up at the same time as your living will, what is the difference? A will is a legal document that becomes effective at your death and specifies how your property is to be disposed of. To be effective, a will must be acknowledged and various other things. A trust is different from a will because a will is you basically saying, this is how I want my property to be disposed of, but the will has to be probated for it to be recognized, for your property to be disposed of under the will. With a trust, you don't have to probate, but you have to populate the trust, so that you still have to, at the time of death, certain things have to go into the trust. So a living trust is set up during your lifetime, and it is effectuated if you populated while you're still alive. And a will doesn't come into effect unless it's actually probated, and you can make the decision at the time of death that your survivors, the executor I want to say your survivors, it's the person that's actually holding the will. If you can't find the will, or somebody's hidden it, then you have to default to intestate or the trust. So whoever is holding that will is making that determination. So again, it's sort of like the Aristotle thing. If your will doesn't get probated, or if it's not in the right hands, then it's though you don't have a will. The next question is, do I need to avoid probate? Revocable living trusts are marketed in many states as a great way to avoid probate, especially in states with complicated administration procedures. In many states, the states are put through court-supervised administrations, and that's one of the things you want to avoid. And in the wills that I've dealt with, you want to have an independent administrator, somebody that's not controlled by the court, because if you have and usually you're going to put that in your will. You're not going to ask that the court control or be dependent upon the court, because it becomes more costly that way, and the court has all the control. So an independent administrator normally is without bond. It's somebody you designate. It's not very expensive, and that particular person is the one that's going to control whether the will is probated or not, and they're the one that's going to hold it. I had a will that I was helping it handle recently, and my client asked me, what do you do if, the will is lost? And if before you die, you want to make sure that your will is probated, to have some control over that, you want to file it with the county clerk. They hold it in place. The original is filed. It's guaranteed to be known that it exists and won't be lost. It won't be hidden in some state, some safe, if you actually file the will with the county clerk, because they're holding the original. Now, whether that will is probate or not, it's going to be up to the independent executor that it's named in your will. And I think it's like $5 in Montgomery County to file it that way. But that's that guarantees that when you die, that everybody knows that you have a will if you file it with the county clerk and ask them to hold that for you. Your independent administrator still may not want to probate it, depending on what the tax laws are, if you have a living trust, but it's going to be up to them, the person that you name as your independent executor, not administrator, independent executor. So you do have a lot of control if you follow with the county clerk at that point. So the next question is, how much in probate expenses will a living trust save? And the answer is it depends. Living trusts are more complicated than wills and typically cost more. They also require the consumer to do more things, such as changing ownership of property in advance. So if you don't do a lot of stuff in advance, having a living trust set up may not really be that advantageous to you. So you want to look at it. And the independent executor of the will has a lot of control on the way things work. I prefer to if a trust has not been effectuated at death and there's going to be a contest, I do prefer to probate the will. It's there's an independent executor already named, because it just makes it a lot cleaner as far as what your legal fees may be. If you're trying to determine whether if there's a will contest or a trust contest, if you go ahead and probate a will that was properly prepared, it's less likely that you're going to have that whoever is contesting it's going to win. And I also think it's beneficial to have a no contest clause in the will, because it's going to prevent the people that want to contest it that aren't named or don't like what they've been given. It's going to, if you have I forgot what the actual name of the clause is, but I believe it's a no contest clause. But if somebody that doesn't like what they were given contest, then usually the way that provision works is they will inherit nothing. So that's kind of a good idea to have that in there too as a provision. So when is using a living trust a good idea? Your lawyer should evaluate your particular situation to determine if a living trust is right for you. Be careful. I'm sorry, my phone just rang. Be careful if the lawyer you consult never uses living trust or always uses living trust, because it's usually individual to that. It's unique to your situation. Can other estate planning tools be used instead of a living trust or will? The traditional and most common method of estate planning involves a will and various disability documents. One advantage of a living trust is its usefulness in the event of incapacity. So that's before, if you want to put your property into a living trust, if you have a power of attorney that's properly authenticated by the terms of that power of attorney, showing that at the time of your incapacity that it's been proven up that by your physician or usually two physicians, so that you don't have somebody that's trying to control your estate by saying that you're incapacitated when you're not, then you can, that's the best way to set up a living trust at that point. But I did have I went to trial recently on establishing that a power of attorney never came into effect due to the incapacity of the person that signed the power of attorney, because there was one son that was trying to control the estate that had improperly had his mother sign a power of attorney. And when all was said and done, the power of attorney was determined to be it never became effective by the bad son. I'm going to call him the evil son. And so it's wise to make sure that before you're determined to be incapacitated, because you want to be able to control your own life, that you have the proper physicians establishing that you are indeed incapacitated. And the proper provisions in your power of attorney that set forth that that's your condition. Okay, so here's another question. I saw a do-it-yourself living trust at the store. Will it work? The answer is maybe or maybe not. It's likely to have some effect, but might not work the way you intend. Wills are complex documents and should be prepared by an attorney. And I say that in answering. I prefer a holographic will, personally. You don't have to go through all of the dance of the will to make it effective. Dean Treese had it right. Just handwrite out your will to say who you want your things to go to. It's a surefire way that it will absolutely be effective. If you file your handwritten will in the county clerk's office to show that it's your last will and testament, actually putting a date on it to say when you prepared it, so someone doesn't have to try to come, one of your, somebody, an unsavory character that may be in your family, to say that this is actually your last will and testament when you've set out what you want, the way you want it, at a time certain. Write it out in handwriting. File it with the county clerk. The county clerk normally requires that it be notarized before they will actually file anything of record. It has to be signed before a notary. So if you want to file it, I don't believe Dean Treese is what's actually filed by a notary. But if you want it filed with the county clerk to make sure that it's not lost, then you'll have to have a notary sign it. But that's not the same as the will dance, and so that's I think the direction you may want to go. All right, so here within our will show, here are the things that you need to do if a loved one dies, because this is usually not something that someone anticipates unless they're in a hospice or you know that they're ill. If somebody dies suddenly, no matter how old they are, here is what you need to do. 13 steps. My loved one has just died. What should I do? This is a concern for everyone. Immediately after a death, there seems to be so much to do. It seems overwhelming, but it should not be overwhelming. So what is the first thing you should do? The first thing is to focus on the course, of course, is the funeral and what you need to do with the person. It must be planned and paid for, or at least in part. So if, to say that the first thing that should be taken care of is the funeral, I would think the first thing is just to make sure that they are, that they are deceased, and to have that looked into by a physician. Here in Montgomery County, it's the JP courts and the Justice of the Peace. We have 5 of them here in Montgomery County. They're actually the people that can handle that. So I would look at the JP court site. They actually handle that. They're the ones that would sign off on the death certificate if you don't have a physician, if it's not in a hospital. Whom should I contact? You should tell the employer and find out if there are any other death benefits connected with his or her employment. So you want to contact their employer if they are employed. Do I have to find the will right away? You should look for the deceased will that we were just talking about, but you actually have 4 years to file a will, so that's not critically important. What should I do with the will and when I find it? And of course, we just discussed that. You have up to 4 years from the time of death to file it. You should contact an attorney to determine whether or not you even want to file a will, because you don't have to. There may not be enough assets in the estate to make that something that you want to go forward and do. It just may be an unnecessary expense. Do I have to probate the will? We just went over that. You don't have to. You want to look first to see the nature of the assets and how they're titled. There may not be anything left in the estate to probate if the person is taking care of it by having their property at time of death go they only hold a life estate in the property they own and have already taken care of that by putting the deed where the property will pass the remainder men of their real property, or they've already turned over their property with their vehicles by having a different name and various other things that you can do. So you can do pre-estate planning, so you don't have to probate, but most people don't do that. Let's see. I'm going to jump right into what is probate instead of answering all the things that you do when someone dies, because I was looking at this list and I'm not really happy with the frequently asked questions. I think they're kind of silly. Okay, so what is probate? We've already talked about that. Probate is the legal process that takes place after someone dies. If the descendant has a legal will in place, the probate court will verify the document and ensure it's the descendant's wishes and that those are followed. Without a last will and testament, the state of Texas will determine how the assets are distributed. Using the services of an experienced probate attorney can help your family more smoothly determine how the probate should work, and they can guide you through it. You don't necessarily have to do that. You can go to Texas Law Help. They have a way to guide you through it without the help of an attorney, and will save you a little bit of money. Attorneys usually probate a will that's properly done, usually cost in the range of $1,500 to $2,500. That may not include them helping you fill out the paperwork at the tax assessor's office to transfer vehicle title and real estate title, but they will at least get the will probated for you and allow you to get the letters testamentary, which you will need to access the person's bank account if they didn't if they had a will, to access a bank account that didn't have a provision of who payable on death account, or the beneficiary of the account, or if it wasn't a joint ownership account, you will need that letters testamentary to access it. The bank will not let you get into it otherwise. If the person had a living trust, the trustee, we usually have I want to say if they have a living trust, they can access their bank accounts. But usually if the person has gone so far as having a living trust, then they've also established they're going to have joint accounts and where their money went, who the beneficiaries are, pay on death accounts. They probably have looked a little bit, gone forward thinking on that, and you won't need a letter of testamentary. But if there's an account, if there's checks payable to the decedent, then you will need a letter of testamentary, and the probate's the way to go. You can get that almost immediately upon filing the will for probate, usually within a few days. The courts work pretty fast with the Zoom hearings they have now. Okay, so the next question is, I have a will, what do I do with it? If you have a loved one that has left a will, an attorney can help you validate the will and honor that person's wishes. Probate is pretty straightforward, though. The amount of work depends heavily upon the circumstances surrounding that person's estate. An attorney can let you know whether you want to do a small estate affidavit or an affidavit of heirship that will take the place of actually probating the will, and tell you whether it's even necessary. When I was a landman and did division orders at an oil and gas company, many people died intestate, and we didn't know what to do with the oil and gas royalties, which were sometimes substantial when that person died. And what we would do when we were contacted by their heirs is we would write them back, ask them to complete an affidavit of heirship, not knowing anything about the estate, just trying to figure out what we needed to do with the oil and gas royalties. We would, even not knowing whether or not there was a will that was going to be probated or not, that really wasn't significant to us. If a will had not been probated, we did not see it in the county clerk's office. Whether or not we would ask them first if one had been filed, and when the decedent died, would ask for a death certificate, ask them to send a certified copy. If they sent us a certified copy of the will and they properly completed an affidavit of heirship, that allowed us to distribute the oil and gas royalties to those heirs. We learned later that there was a will, then we would put a hold on those royalties, and when we redistribute and ask those people that we distributed to pay the money back to the actual heirs. And that rarely happened. People, pretty much when somebody was getting ready to die, people were jumping all over it. They knew where that money was going to go, and if there was a will, and if it was going to be probated. Okay, so what is the difference between a dependent and an independent administration? We hear this a lot, and we went over it just briefly in this show. So just for, to kind of give you the bullet points on that, during a probate administration, either the court handles all of the affairs. That's a dependent administration. It's dependent upon the court, and they will appoint an administrator or assigns them to the estate administrator that's named in the will, and that's an independent administration. There are arguments for each style. A dependent administration, in that case, the court approves every sale and every distribution of property and the assets, as well as the payment of the estate liabilities. Every step of the process is micromanaged by the court. You definitely don't want to go this direction because it goes down to the penny. You're paying accountants. You're paying the court administrator that's been appointed. You're paying a litany of people, and there's always an argument between the heirs of where it goes, where the money is going. And so, if possible, always try to have it independent of the court because you have no control over it when the court gets it. So, an independent administration, the court assigns an administrator to oversee the daily affairs of the descendant's estate. The individual has the power to make all estate-related decisions and report back to the court. In both a dependent and independent administration, there are certain arguments, testimony and evidence, and applications that must be produced and completed in a precise manner. The vital information that allows the court to make the right decisions with regard to the descendant's estate. And I want to add that you can have an independent administrator that is not the independent executor named in the will, but that's rare. But when it does happen, the court will usually pick a wife or when the court learns that there's only one heir, then it would go to that person. And in that case, it's not nearly as bad as not having a will at all. You do have to have an independent administrator if there is no will, obviously, because you don't have an independent executor named. But in that case, I think an affidavit of heirship, you want to go a different direction rather than have the court kind of stepping in. I think in the case of like Prince, he would definitely have had to have an administrator because he didn't have a will and he had millions and millions and billions of dollars in that case. Okay, so I have a station manager, Dick, who's telling me to wind up. We're going to have Will Administrations Part 2 with many more frequently asked questions and not just the dry details of the law that we went over today. And so next week, Will Administrations Part 2. And so we will see you next week at noon. And remember, the most important thing you can do during these Christmas holidays and Advent is to serve God by serving others. And we'll see you next week.